So we need to talk about a new case just granted review by the Supreme Court. This case attempts to build off of a prior 9-0 unanimous decision of the Supreme Court, which impacts our rights to prevent the unlawful search and seizure and also confiscation of firearms within our home without a warrant. So let's break down what is happening in this critical challenge. Now, before we jump into this video, I want to thank one of the main supporters of this channel, which is FirstForm. You guys know that FirstForm is an amazing company. They're pro-freedom, pro-America. They believe in the Second Amendment and what we talk about here on the channel. So I want to ask you guys for a huge favor. If you're kind of on a health journey or you need supplements or maybe even workout apparel, check them out using my link down below. Show them support because they support what we do here on the channel. And also, if you use my link down below and you order something $50 or more, you will get a free 4-pack of energy drinks. As I mentioned in the intro, in this video, we're going to be discussing a new Supreme Court case that was recently granted review. And this involves when police officers and potentially even the government can enter someone's home without a warrant. This case tries to use a prior unanimous decision by the Supreme Court, which involved the warrantless search and seizure of firearms within someone's home. The new challenge pending in front of the Supreme Court is called Case versus Montana. This challenge is important for all gun owners, especially because it involves when law enforcement can use legal workarounds to not only enter your home without a warrant, but also potentially confiscate guns and all of your items as well without a warrant. This challenge, Case versus Montana, attempts to expand upon a prior 9-0 unanimous decision issued by the Supreme Court in a case called Caniglia versus Strom. Now, the facts surrounding this challenge here, the Case versus Montana case, are very interesting. Essentially, this lawsuit results from Trevor Case's ex-girlfriend calling police saying that he had threatened to harm himself and that also he may have a gun. Apparently, all the police officers knew Mr. Case, and there was a history of, mental health issues and interactions prior with law enforcement and this individual. Now, when the 4 police officers arrived at his home, they looked through all the windows, they looked into the rooms, and did not see Mr. Case. However, one of the police officers noticed an empty handgun that was in a holster, and she also saw a notepad. They believed that maybe he was harming himself, and so the police officers knocked on the door, shine lights and flashlights, through the windows, but Mr. Case did not respond. After about 40 minutes at the house, the police officers then decided to enter the home through the front door that was also unlocked. Now, many of the officers before doing that expressed concerns about entering the home because of prior interactions that they had with Mr. Case and also the threats that were expressed to them by the ex-girlfriend, that things that he had said on the phone. They were worried that if they entered the home, maybe they would engage in a shootout with the cops. So, a lot of them were very concerned about entering the home. There was also a short discussion between the 4 police officers about maybe calling his father to come and to enter the home and have a conversation with him, and also maybe even to try to call Mr. Case, call him through his cell phone and see if he would answer. Ultimately, the police officer decided to not do any of that. Instead, they decided to enter the home. They grabbed their rifles. I believe they also went and gathered ballistic shields, and so they entered the home. Now, when the 4 police officers entered the home, 2 of them went downstairs, 2 went upstairs. Now, when one of the police officers entered one of the upstairs bedrooms, he saw a curtain open. He said it jerked open. He saw Mr. Case's face, and he also saw a black object. The police officer reacted to that and then shot Mr. Case in the arm and then also in the stomach. They gave him medical attention, and then after that, they kind of searched the home and they recovered a handgun lying in a laundry basket, kind of a hamper that was near Mr. Case. Now, this all led to charges against Mr. Case, and he argued that the police officers in their warrantless entry into his home violated his 4th Amendment rights. And so he also argued that the gun and other evidence found within the home should be suppressed. Those arguments were ultimately rejected by the lower court, and then this eventually made its way to the Montana Supreme Court, who issued a 4-3 split decision against Mr. Case. This challenge has now made its way to the United States Supreme Court, who has now granted review to this challenge. The question presented to the Supreme Court that they will decide is whether law enforcement may enter a home without a search warrant based on less than probable cause that an emergency is occurring, or whether the emergency aid exception requires probable cause. Now, in his official petition to the Supreme Court, Mr. Case argues that while this court has recognized exceptions to the exigent circumstances, it has jealously and carefully drawn those exceptions. The court should take the same approach in defining the exigency exceptions for emergency aid and hold that officials must have probable cause to believe an emergency exists before making a warrantless home entry. He goes on to argue that the Supreme Court rejected any freestanding community caretaking exception in Caniglia versus Strom. However, the Montana Supreme Court upheld the officer's warrantless entry into the home of Mr. Case on the basis of a community caretaking test requiring only reasonable suspicion of an emergency. That decision, he argues, not only contravenes Caniglia, but more fundamentally adopts a less stringent standard of knowledge. Mr. Case also argued that the search was not justified under the community caretaking doctrine, which was struck down by the Supreme Court in Caniglia versus Strom. He argues, like the dissenting opinions on the Montana Supreme Court, that in Caniglia, the Supreme Court rejected treating community caretaking as a standalone exception to the warrant requirement. Instead, it is still tied to exigent circumstances and a showing of probable cause. But the Supreme Court of Montana deviated from what the United States Supreme Court said in their ruling and continued to apply their own view of the analysis. Now, if you're not aware of what happened in the Caniglia case, which is kind of the basis and foundation of what now the case challenge tends to expand upon, essentially in Caniglia, a husband and wife got into an argument. And during that argument, the husband kind of got out a gun, I believe, put it on the table and told his wife to just take it and put him out of his misery. The wife ultimately left the home, stayed at a hotel overnight. The next morning, she couldn't get a hold of her husband, so she called police. They all arrived at the house, found the husband on the front porch. The police officers ultimately decided to take the husband to a hospital for a psych evaluation. But before leaving the home, Mr. Caniglia told the police officers that he did not want them to take his guns, and they all agreed. But after the ambulance took Mr. Caniglia away, the police officers then went to the wife, lied to her, and said that the husband had consented to the taking of his guns, so she allowed them to enter the home and to take the firearms. That case eventually made its way to the Supreme Court back in 2021, and on review, the Supreme Court issued a rare 9-0 unanimous ruling in favor of Mr. Caniglia. In that case, the Supreme Court struck down the community caretaking rationale that was being used to enter the home and seize those firearms. Now, since that decision by the Supreme Court, they have not considered the circumstances of when police officers may enter a home since essentially 2021. And this Caniglia decision now is being sought for re-review through this case challenge and potentially also an expansion. Now, recently, Amicus briefs were submitted in support of Mr. Case to the United States Supreme Court. One was recently submitted by the Long Ang Institute, which advocates for the laws of nature and nature's God as used in the Declaration of Independence. Now, in their brief, they argue that the framers of our Constitution knew that the government was neither compassionate nor a caretaker. They understood that civil government was based on force and violence. God's own description of the character of the civil governments of the earth in 1 Samuel 8 is brutally honest. Civil government will take our land, crops, and property, our sons and daughters, wage war. They go on to argue that given the state's violent propensities, the framers attempted to protect the family, its dominion, and its property from the government and its agents. They mentioned that certain amendments were ratified by the framers with this reality in mind, including the Second Amendment. These rights, they say, ensure individuals can push back against those types of infringements. They write that the Second Amendment's prohibition on any infringement of the right of the people to keep and bear arms is a critical means by which both the freedom and the privacy of the home and the family may actually be secured. And based on that, they argue that the Montana Supreme Court's decision must be reversed by the U.S. Supreme Court because it goes against what the framers put in place. So now multiple organizations are jumping in support of Mr. Case's challenge in the Supreme Court. This is important because it impacts everyone's protections against these types of warrant exceptions. The Supreme Court now has an opportunity to clarify and expand upon the 9-0 unanimous ruling in the Caniglia case, which can have direct downstream implications on what protections we all have from police officers and the government from entering our home under warrantless search and seizure exceptions. So this is a very interesting and controversial case. It's now getting a lot of support from different organizations who are filing amicus briefs. And this is a case that we're going to be watching closely to see how the Supreme Court actually handles it and how do they come out on this issue. So that's what's going on in this critical warrantless search and seizure challenge that's currently in front of the Supreme Court that they will now hear arguments on this term. As we have more information, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to simply subscribe to the channel. Also, you can check out my website, armedscholar.com. We have the free legal guide over there that you can sign up for. It's a PDF. All you have to do is put in your email and we will email you over the PDF. And then also you are getting some additional follow-up emails with free educational information. Again, check out the website, armedscholar.com, where we have that and a lot of other things for you as well. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.